Welcome to True North Hotel Group's OSHA Training Series. Introduction to OSHA. OSHA required training for all managers and supervisors. Please pay special attention to the following video and complete the test when you are finished watching. The purpose of today's training is to provide supervisors with introductory information about OSHA, including the rights of whistleblowers. The topics we will cover are: Number 1, why is OSHA important to you? Number 2, what rights exist under OSHA? Number 3, what responsibilities does your employer have under OSHA? Number 4, what do the OSHA standards say? Number 5, how are OSHA inspections conducted? And number 6, where can you go for help? Topic number 1, why is OSHA important to you? OSHA was created because until 1970, there were no national laws for safety or health hazards. Did you know that on average 15 workers die every day from job injuries? Every year, over 5,600 Americans die from workplace injuries, and over 4 million non-fatal workplace injuries and illnesses are reported annually. The mission of OSHA is to save lives, prevent injuries, and protect the health of America's workers. Some of the things OSHA does to carry out its mission are develop job safety and health standards and enforce them through worksite inspections, maintain a reporting and record-keeping system to keep track of job-related injuries and illnesses, and provide training programs to increase knowledge about occupational safety and health. Topic number 2, you have the right to. The next several slides will help explain your rights under the OSHA Act. Under the OSHA Act, you have the right to a safe and healthful workplace. The creation of OSHA provided workers with the right to a safe and healthful workplace. Section 5A1 of the OSHA Act states, each employer shall furnish to each of his employees employment and a place of employment which are free from recognized hazards that are causing or are likely to cause death or serious physical harm to his employees. You also have the right to know about hazardous chemicals. Employers must have a written, complete hazard communication program that includes information on container labeling, safety data sheets, and worker training. The training must include the physical and health hazards of the chemicals and how workers can protect themselves, including specific procedures the employer has implemented to protect workers, such as work practices, emergency procedures, and personal protective equipment. Another right under the OSHA Act is the right to information about injuries and illnesses. OSHA's record-keeping rule requires most employers with more than 10 workers to keep a log of injuries and illnesses. Workers have the right to review the current log as well as the log stored for the past 5 years. Workers also have the right to view the annually posted summary of the injuries and illnesses, OSHA Form 300A. You also have the right to complain or request corrections. Workers may bring up safety and health concerns in the workplace to their employers without fear of discharge or discrimination, as long as the complaint is made in good faith. OSHA regulations protect workers who complain to their employer about unsafe or unhealthful conditions in the workplace. You also have the right to training. Workers have a right to get training from employers on a variety of health and safety hazards and standards that employers must follow. Some required training covers topics such as lockout-tagout, bloodborne pathogens, noise, confined spaces, fall hazards in construction, personal protective equipment, and a variety of other subjects. Under Article 29 CFR 1910.1020 of the OSHA Act, you have the right to examine and copy exposure and medical records. Another one of your rights under the OSHA Act is to refuse to work due to dangerous conditions. Refusing to do a job because of potentially unsafe workplace conditions is not ordinarily an employee right. As a general rule, you don't have the right to walk off the job due to unsafe or potentially unsafe conditions. Stay on the job until the problem can be resolved. However, employees do have a right to refuse to do a job if they believe in good faith that they are exposed to imminent danger. Good faith means that even if imminent danger is not found to exist, the worker had reasonable grounds to believe that it did exist. Another right is your right to file a complaint with OSHA. Workers may file a complaint with OSHA if they believe a violation of a safety or health standard or imminent danger situation exists in the workplace. Workers may request that their name not be revealed to the employer. If a worker files a complaint, they have the right to find out OSHA's action on the complaint and request a review if an inspection was not made. You also have the right to participate in an OSHA inspection. Employee representative can accompany OSHA inspectors. Workers can talk to the inspectors privately, and workers may point out hazards, describe injuries, illnesses, or near misses that resulted from those hazards, and describe any concern they have about a safety or health issue. Workers can also find out about inspection results, abatement measures, and may object to dates set for violations to be corrected. If your complaint is made in good faith, you also have the right to be free from retaliation. Workers have the right to be free from retaliation for exercising safety and health rights. Workers have a right to seek safety and health on the job without fear of punishment. This right is spelled out in Section 11C of the OSHA Act. Workers have 30 days to contact OSHA if they feel they have been punished for exercising their safety and health rights. The following is a list of protected activity under Section 11C, Whistleblower Protection. You may file a complaint with OSHA. You can file a health or safety complaint with a supervisor or management. Causing a proceeding under the OSHA Act, i.e. an inspection, to happen is also protected. Providing testimony relating to health and safety issues. Communicating with an employee or union regarding the issue of health and safety in the workplace. Refusing to perform a task that you believe to be dangerous, and exercising the right to participate in an OSHA inspection or communicate with a compliance officer. Below is a list of unlawful retaliatory conduct in violation of Section 11C. If an employee engages in a protected activity, unlawful retaliatory conduct includes the following adverse actions: blacklisting, demoting, denying overtime, denying a promotion, denying benefits, disciplining, failing to hire or rehire, a discharge or layoff, intimidation, threats, harmful reassignment, reduced pay or hours, and suspension. If a retaliation complaint is filed, OSHA will investigate and will conclude in favor of the employee if the investigation reveals 4 things. Number 1, the employee engaged in a protected activity. Number 2, the employer knew of or suspected the protected activity. Number 3, the employer took an adverse action against the employee. And number 4, the protected activity motivated or contributed to the adverse action. Topic number 3. What responsibilities does your employer have under OSHA? Your employer must provide a workplace free from recognized hazards and comply with OSHA standards. They must also provide training required by OSHA standards. Employers must keep records of injuries and illnesses and provide medical exams when required by OSHA standards and provide workers access to their exposure and medical records. The employer must not discriminate against workers who exercise their rights under the Act, Section 11C. They must post OSHA citations and abatement verification notices. And finally, they must provide and pay for PPE, personal protection equipment. Let's take a closer look at some of the things employers are required to do. Employers are required to keep records of injuries and illnesses. OSHA provides a reporting and recording checklist. Under this list, employers must report each worker death, report each incident that hospitalizes 3 or more workers, maintain injury and illness records, inform workers how to report an injury or illness to the employer, make records available to workers, allow OSHA access to all records, and post annual summary of injuries and illnesses. Employers are also required to provide and pay for PPE. PPE is personal protective equipment. PPE is equipment worn to minimize exposure to a variety of hazards. Gloves, eye protection, and hearing protection are some of these. Employers are required to determine if PPE should be used to protect their workers. This rule was effective February 13, 2008 and implemented May 15, 2008. Under this rule, employers are required to train employees in the use and care of personal protective equipment. Employers cannot require workers to provide their own PPE. If they do, the use of their own PPE must be voluntary. Even if a worker provides his own PPE, the employer must ensure it is adequate to protect the worker. Certain types of PPE may not have to be provided by employers in certain circumstances, such as non-specialty steel-toed shoes, ordinary clothing to protect from the weather like parkas, and lifting belts. Employers should also provide safety and health program. It has been found that effective management of a worker safety and health program reduces the extent and severity of work-related injuries and illnesses, improves employee morale and productivity, and reduces workers' compensation costs. Here are some common characteristics of a safety and health program at an exemplary workplace. An exemplary workplace will use organized and systematic methods to assign responsibility to managers, supervisors, and employees, to inspect regularly for and control hazards, and orient and train all employees to eliminate or avoid hazards. Some major elements of an effective program at an exemplary workplace include provisions for systematic identification, evaluation, and prevention or control of hazards. It also goes beyond specific requirements of the law to address all hazards. An exemplary workplace will have a written program. The fact that the program is in writing is much less important than its actual effectiveness. As size and complexity of a work site or process increases, so does the need for written guidance. Another major part of a safety and health program at an exemplary workplace is management commitment and employee involvement. Management commitment and employee involvement are complementary. Management commitment provides the motivating force and resources for organizing and controlling activities within the organization. Employee involvement provides the means through which workers develop and express their own commitment to safety and health protection. Here are a few recommended actions to take when starting a safety and health program. State clearly a worksite safety and health policy. Establish and communicate a clear goal and objective for the safety and health program. And provide visible top management involvement when implementing the program. Managers and supervisors should encourage employee involvement in the program and the decisions that affect their safety and health, such as inspection or hazard analysis teams, developing or revising safe work rules, training new hires or coworkers, and assisting in accident investigations. Managers should also assign and communicate responsibility for all aspects of the program. Other recommended actions when implementing a safety and health program are to provide adequate authority and resources to responsible parties, hold managers, supervisors, and employees accountable for meeting those responsibilities, and be sure and review the program operations at least once annually to evaluate and identify deficiencies and revise as needed. Every exemplary safety and health program has in-depth worksite analysis. Worksite analysis involves a variety of worksite examinations to identify not only existing hazards, but also conditions and operations where changes might occur to create hazards. Effective management actively analyzes the work and the worksite to anticipate and prevent harmful occurrences. The next few slides will give recommended actions so that all hazards are identified. First, conduct comprehensive baseline and periodic surveys for safety and health. Analyze planned and new facilities, processes, materials, and equipment, and perform routine job hazard analysis. Companies must provide regular site safety and health inspections and also provide a reliable system for employees without fear of reprisal to notify management about apparent hazardous conditions and to receive timely and appropriate responses. And finally, the company must provide for investigation of accidents and near-miss incidents so that their causes and means for prevention are identified. And they must analyze injury and illness trends over time so that patterns with common causes can be identified and prevented. Our next topic is hazard prevention and control. Prevention and control is triggered by a determination that a hazard or potential hazard exists. Where feasible, prevent hazards by effective design of the job or job site. Where elimination is not feasible, control hazards to prevent unsafe and unhealthful exposure. Elimination or control must be accomplished in a timely manner. In order to have exemplary hazard prevention and control, the company must establish procedures for timely correction or control of hazards, including but not limited to engineering techniques where feasible and appropriate, procedures for safe work which are understood and followed as a result of training, positive reinforcement, correction of unsafe performance, and enforcement, a provision for personal protective equipment, and administrative controls. Another employer responsibility is safety and health training. Employers are responsible for facility and equipment maintenance, planning and preparing for emergencies, training and drills as needed, establishing a medical program, having first aid on site, and if needed, a physician or emergency care nearby. Employers need to ensure that all employees understand the hazards to which they may be exposed and how to prevent harm to themselves and others from exposure to these hazards. Each company is required to ensure that its supervisors carry out their safety and health responsibilities, including but not limited to analyzing the work under their supervision to identify unrecognized potential hazards, maintaining physical protections in work areas, and reinforcing employee training through continual performance feedback and, if needed, enforcement of the safe work practices. And finally, companies are required to ensure that its managers understand their safety and health responsibilities, as described under the Management Commitment and Employee Involvement element of the foregoing guidelines. The next topic is OSHA standards. OSHA standards fall into 4 categories: general industry, construction, maritime, and agriculture. OSHA issues standards for a wide variety of workplace hazards. Where there are no specific OSHA standards, employers must comply with the General Duty Clause, Section 5(1)(a). Topic number 5 is OSHA inspections. The OSHA Act authorizes OSHA compliance, safety, and health officers to conduct workplace inspections at reasonable times. OSHA conducts inspections without advance notice except in rare circumstances, such as imminent danger. In fact, anyone who tells an employer about an OSHA inspection in advance can receive fines or jail time. Below you will see a list of OSHA's inspection priority. First priority is that of imminent danger. Reasonable certainty and immediate danger exists. Second priority is for fatalities or catastrophes that are reported to OSHA. They will be inspected as soon as possible. Third priority is for complaints or referrals. Worker or worker representative can file a complaint about a safety or health hazard. And the fourth priority is programmed inspections. They cover industries' employers with high injury and illness rates, specific hazards, or other exposures. On this slide, you will see a list of OSHA citations and penalties. There are 4 types of violations. The first type is a willful violation, a violation that the employer intentionally and knowingly commits, or a violation that the employer commits with plain indifference to the law. Penalties for this are up to $70,000 for each willful violation, with a minimum penalty of $5,000 for each willful violation. The next type of violation is serious, a violation where there is substantial probability that death or serious physical harm could result and that the employer knew or should have known of the hazard. There is a mandatory penalty for serious violations, which may be up to $7,000. The next is other than serious. A violation that has a direct relationship to safety and health, but probably would not cause death or serious physical harm. OSHA may propose a penalty of up to $7,000 for each other than serious violation. And finally, the repeated violation. A violation that is the same or similar to a previous violation. OSHA may propose penalties of up to $70,000 for each repeated violation. Our final topic today will be where can you go for help? We will discuss sources within the workplace or worksite, sources outside the workplace or worksite, and how to file an OSHA complaint. Your first stop for OSHA help should be sources within your workplace or worksite. Your employer or supervisor and coworkers can offer guidance. You can check the safety data sheets for information on chemicals, and make sure you read all labels and warning signs. You can also check your employee orientation manuals and other training materials if you need assistance. If you need additional information, here are some sources outside of your workplace or work site that may be helpful. OSHA website, www.osha.gov, and the OSHA offices. You can call or write. Compliance assistance specialists in the area offices. The National Institute for Occupational Safety and Health, which is OSHA's sister agency. OSHA Training Institute Education Centers. Doctors, nurses, and other healthcare providers. Public libraries, and other local and community-based resources. And finally, if you need to file an OSHA complaint, you may go to the OSHA's website and download the OSHA 7 form. Prepare and file the complaint online. Workers can file a complaint, or a worker representative can file a complaint. You may also telephone or visit your local, regional, or area offices to discuss your concerns. Complete the form, be specific, and include appropriate details. OSHA will determine if an inspection is necessary, and workers do not have to reveal their names. Let's sum up today's training. This lesson covered the importance of OSHA, including the history of safety and health regulation leading to the creation of OSHA and OSHA's mission. It also covered workers' rights under OSHA, employer responsibilities and health and safety programs, OSHA standards, OSHA inspections, and safety and health resources, including how to file a complaint. Thank you for viewing the True North Hotel Group OSHA Training Series, Required Training for Managers and Supervisors. Please click the box above to serve as your signature that you have watched and understand the content of this training.